Welcome to Fresh Start with Jason Cline.
Welcome back to Fresh Start with Jason Cline, the podcast where New Mexico residents find real solutions to overwhelming debt. Now, Jason Cline is an experienced bankruptcy attorney based in Albuquerque who's helped people across the state get a genuine financial fresh start. I'm Evan Mack, and today we're breaking down the two most common types of personal bankruptcy, that's Chapter 7 and Chapter 13, and talking about how to know which option may be the best fit for your situation. Jason, my brother, welcome back.
Thank you, Evan.
Awesome. Jason, people always hear about Chapter 7, Chapter 13 all the time, but what most people really don't understand is the difference. How do you explain these two options when you first meet with the client?
Well, that's a great question, and it's probably the biggest one that people have after they've done a bit of online research. But before we get into the two chapters, we need to discuss a few things that are common to both chapters. First, I need to define the different types of debt. So in any personal bankruptcy, there are three types of debts. These are secured debts, priority unsecured debts, and general unsecured debts. I'm going to give examples of each of these, but the examples I give are not a full list. And to ensure that you're properly categorizing your debts, it's important to talk with an experienced bankruptcy attorney. Additionally, we also need to talk about bankruptcy exemptions. So secured debt is anything that you have pledged property against the debt. So if you don't pay it, the creditor can get the property and sell it to recoup their debt. Commonly, this is going to be mortgages and car loans, but it can also be furniture loans, electronic loans, solar loans. I will note, though, that loans with Affirm and Synchrony Bank are usually general unsecured, not secured debts. There are choices with secured debts and property. You can continue to pay for them and keep the property, or you can surrender the property and discharge any debt remaining after the creditor sells it. The next type is a priority unsecured debt. These are things like child support, alimony, and certain taxes. So priority debts can't be discharged in bankruptcy, and they must be paid. And finally, there's general unsecured debts. These are the important ones because these are the ones that we're going to discharge in the bankruptcy. General unsecured debts are most commonly credit cards, medical bills, personal loans, collection accounts. However, they are really anything that cannot be considered to be a secured debt or a priority debt. So also debts with family members and friends, unpaid utility bills, all of these things can be general unsecured debts as well. It is important to note that student loans are general unsecured debts, but they're almost always non-dischargeable in bankruptcy. All right, so beyond what debts can be discharged in the bankruptcy, the other thing that that people are most concerned with is keeping their money and their property in bankruptcy. And this is especially true with people who have done some online research and have read the horror stories about others who have lost everything by filing for bankruptcy. But rest assured that contrary to what you might find online, most people keep everything. But this is where having an experienced bankruptcy attorney is important. Money and property are not inherently protected in a bankruptcy. We have to claim what are called exemptions to them to protect them. Using the correct exemptions is important, and your attorney will guide you through this. All right, now with the basic understanding of the types of debt and protecting your money and property, we can start to talk about the two most common chapters of personal bankruptcy. So Chapter 7 is the most common type of personal bankruptcy. It's what's considered to be a straight bankruptcy. You discharge your unsecured debt, and in most cases, you'll keep all of your money and property. They're over with relatively quickly, right in between 3 and 4 months from filing to finish. And almost everyone I talk to wants to file under Chapter 7. However, there are income qualifications to file for Chapter 7, and there are benefits that Chapter 13 can provide that Chapter 7 cannot. Chapter 13 is the second most common type of personal bankruptcy to file. It's a payment plan over a period of 3 to 5 years where some debt is repaid. There are many reasons why some debt needs to be repaid or why someone would want to repay debts, but the overall result of a Chapter 13 is the same as a Chapter 7. Any general unsecured debts remaining at the end of the payment plan are discharged, and in most cases, you'll keep all of your money and property.
So Jason, you kind of summed up those pretty well from Chapter 7 to Chapter 13, but one concern people often have is keeping their home or their car. You kind of mentioned it, but how do those protections differ between Chapter 7 and then Chapter 13?
Okay, so you're correct, Evan. This is a question that I hear in nearly all of my consults, and usually it's one of the first things people ask me. Rest assured, in both chapters, you're able to keep your house and your car, but there are some caveats to this. In Chapter 7, you can keep them so long as we can claim a full exemption on them and you're current on your payments for them. If we cannot claim a full exemption, the bankruptcy trustee can take them, sell them, and pay creditors the non-exempt value of the property. Also, if you're not current on your payments, Chapter 7 will temporarily prevent the secured creditor from getting the property, but once the automatic stay is no longer in place, they can still get the property if you don't catch it up. Now, in Chapter 13, you can keep property even if we cannot claim a full exemption on it or you're not current on the payments. You can pay back the non-exempt portions in a Chapter 13 plan or catch up on payments that you're behind. It's important to speak with an experienced bankruptcy attorney to make sure you'll be able to keep your home and your car.
So Jason, Chapter 13 can look a little bit different from state to state. How does it typically work here in New Mexico? What makes it unique for local filers?
So overall, bankruptcy is federal, so the overarching law is going to be the same no matter where you're at. But there are nuances per state. There's a federal form for the Chapter 13 plan, but states can opt out of using it and replace it with their own. New Mexico is one of those. So there is a New Mexico state Chapter 13 plan. And things like with your mortgage, if you're more than 2 payments behind on it, you can catch up those arrears in the Chapter 13 plan. However, you also have to make your regular monthly mortgage payments through it. So you'll make the payments to a bankruptcy trustee, and she'll send those out to the mortgage company to get those paid. And it does make your plan payment higher, but it's actually a good thing. One of the requirements of Chapter 13 is that you remain current on your mortgage payments, and this ensures that you'll do that. But Chapter 13 can be really complicated, and it's important to speak to an experienced bankruptcy attorney to find out what it can do for you.
So Jason, for someone who qualifies for both chapters, what factors usually guide your recommendation one way or the other?
Bankruptcy is not one size fits all. Each person has their own individual needs in their bankruptcies. I mean, if someone is current on all their payments on secured debts, they don't have priority debts, or they don't have large amounts of them, or they're just overwhelmed with general unsecured debt and they don't have any issues with those, Chapter 7 could be the way to go. But if someone's behind on their secured debts for property that they want to keep, they have a large amount of the non-dischargeable tax debts, or they're behind on child support or alimony, or even if they owe a lot of money on their vehicle, we can bring it down to its value rather than what they owe on it. So Chapter 13 could be the way to go then. But really, the most important thing is to speak with an experienced bankruptcy attorney about this decision. So the information that you find online, it can be misleading or just false.
So Jason, I think people always want to know how long things take, especially when it comes to a process as complicated as this for some people. So how long does the process usually take from filing to discharge in each chapter, and what should clients expect during that time?
That's a very good question. And in Chapter 7, the process takes right in between 3 and 4 months from filing to finish. When the case is filed, the automatic stay goes into place immediately, and that's what protects you from collection actions. Approximately 30 days from the filing date, there'll be a meeting with the trustee. It's held by Zoom. The meeting is called a trustees meeting, 341 meeting, or a creditors meeting. The meeting is generally a quick, easy proceeding that takes about 3 to 5 minutes, where the trustee asks some questions about your case that should be based on information that you provided in your bankruptcy petition. It's rare for creditors to show up to this meeting, and really it's nothing to worry about. 60 days from the date of the trustees meeting is the last day that anyone can object to discharge. Objections to discharge are very rare. The day after that deadline, it'll go to the judge to sign off on the discharge order, and it usually takes a week or 2 for this to occur. There are not many requirements after filing. You have to show up to the meeting with the trustee, complete a credit counseling course that can be done online and takes about an hour, and you might need to provide some additional paperwork to your attorney. In Chapter 13, the process takes 3 to 5 years from filing to finish. The discharge order enters after the final payment on the Chapter 13 plan is made. Just like in Chapter 7, the automatic stay goes into place immediately upon filing to protect you from all collection actions. And approximately 30 days later, we're going to meet with the trustee as well by Zoom. This meeting with the trustee takes about 10 minutes, though, because the trustee will review the terms of your Chapter 13 plan as well. Further, you'll still need to complete that second credit counseling course. But this is where the similarities end with Chapter 7. 30 days after the filing date is when you have to make your first payment on your Chapter 13 plan, and then it'll be due on the same date of each month thereafter. There's additional hearings in Chapter 13 as well. Around 30 days after the trustees meeting, there's a preliminary hearing on confirmation of your plan. Your attorney appears at this, and you don't have to. From there, a final hearing on confirmation may be set. If there were to be a final hearing, you would have to appear, but this is rare. Most of the time, your attorney is able to get your plan confirmed without the need of a final hearing. Once your plan is confirmed, your only responsibility is to continue making your monthly payments. Once they are completed, your attorney will have you sign a certification for discharge, and the trustee will perform her final tasks. Then your discharge order will enter within a month or two. It's important to note, though, that over a period of 3 to 5 years, things happen, like job loss, the need to buy a car, or emergency expenses that arise. At these times, your attorney can help you, so make sure to reach out to them as soon as possible.
Yeah, Jason, I wanted to circle back maybe to the beginning of our conversation about the difference between Chapter 7 and Chapter 13. Can you comment on what kind of financial situation usually makes someone a good candidate for Chapter 7, that kind of bankruptcy?
There are income qualifications to file under Chapter 7. We run your total gross, that's before tax, household income through a test by looking at your previous 6 months of pay, creating a monthly average from it, and then multiplying that by 12. Then we compare this number to the annual median income for a household of your size in the area that you live in. If you're below the median income level, you'll likely qualify for a Chapter 7. If you are above it, we have to continue to a second portion of this test called the means test. Here, we'll deduct your living expenses from your income. These deductions are based both on actual and IRS standard deductions. And if after these deductions are taken, you're showing $100 or less of disposable income, you again are likely to qualify for a Chapter 7. If there's more, there are still a few other ways of qualifying for a Chapter 7, but you may be looking at having to file a Chapter 13. It's important to have an experienced bankruptcy attorney run this test. There are a lot of nuances to it that online calculators cannot catch.
So to the flip side of that, when does Chapter 13 make more sense? What kind of client or circumstances does it tend to help the most if they're not going for Chapter 7?
First, you can be forced to file a Chapter 13. If your disposable income determined in the means test is over $100 monthly, and your attorney cannot get you to qualify under any other of the less likely situations, you'll have to do a Chapter 13.
Okay.
The amount of disposable income determined by the means test becomes the amount that you repay your general unsecured creditors monthly for 5 years through a Chapter 13 payment plan. Anything remaining on these general unsecured debts at the end of the plan is discharged just like in Chapter 7. Also, you cannot pay more than everything. So if your disposable income shows that you can pay all of your general unsecured debt with interest at 3% within 5 years, you cannot be made to pay more than this. However, even if you do qualify for Chapter 7, there's still reasons to look at Chapter 13. Chapter 13 is a more powerful bankruptcy than Chapter 7. In Chapter 7, the only options you have with secured debt is to pay it or surrender it. And for priority debt, you have to deal with it on your own. There's no options with it. However, in Chapter 13, if you're behind on secured debt, there are options to get the arrears repaid. And in certain circumstances, you can modify the secured debts. For non-mortgage debts, there are times that the principal amount of the debt can be reduced to the value of the property instead of what you owe on it. Also, if a house is in foreclosure or a car is in danger of repossession, you can save them in a Chapter 13. And additionally, with priority debts like taxes, you can repay it with no additional interest or penalties, or with child support or alimony, you can catch up arrears.
So Jason, let's talk about, stigmas or maybe some common misconceptions you hear about Chapter 7 and Chapter 13 that you wish people understood before they make this important decision.
Well, the biggest misconception is that you're going to lose all your property.
Right.
But as we've discussed here, it's actually more common to keep everything. People also believe based on information they attain online, that if they're above the median income level, they cannot file for Chapter 7. But also, as we discussed earlier, this is not the case. There is still a possibility to qualify even if you're above the median. Additionally, people believe that they have to pay back everything in a Chapter 13 plan.
Yeah.
This is also not the case. In most cases, a good portion or even all of the general unsecured debt is discharged and not paid back. So there's so many myths and so much bad information to find online about bankruptcy filings. The best thing to do is to stop trusting attorney Google or ChatGPT and set an appointment for a consultation with an experienced bankruptcy attorney. My consultations are free, and there's no obligation to move forward with anything.
Good stuff, Jason. And to wrap things up, when someone sits down with you and they try to figure out what chapter fits best, what do you focus on to help them walk away with that confidence in their next step?
I think this question recaps everything we've talked about today, Evan. Since bankruptcy is not one size fits all, people need to walk away feeling like I've seen their situation, and I'm not giving them cookie cutter answers. I will focus on their income and their property to ensure that they keep everything and know where they qualify. There should be no question as to which chapter they do, or even if bankruptcy is right for them at all. At the conclusion, they should feel less stress and like a weight has been taken off their shoulders because of the confidence they feel in their decision.
Jason Cline, sir, thank you for your time as always.
Oh, thank you, Evan.
Awesome. And thank you all for joining us on Fresh Start with Jason Cline. If you're in New Mexico and wondering whether Chapter 7 or Chapter 13 is right for you, visit attorneyjasoncline.com to schedule that free consultation that he was just talking about. And remember, you don't have to face financial hardship alone. There's always a way forward. Be sure to subscribe, leave a review, and share this episode with someone else that might need it. Thank you so much. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.